So good morning, everyone. Thanks for joining us today. My name is Dawn LeBeau, and I'm the program officer here at Occupton. Our mission at Occupton is to transform native agricultural and food economies by delivering creative capital, leading paradigm changes, and enhancing producer prosperity across Indian country. And we have Mr. Jim Wabindato from the Indian Land Tenure Foundation. He's the program officer with them, and he will be presenting today. So I will go ahead and pass it over to him. Thank you.
Good morning, good afternoon, everyone. As Dawn said, my name is Jim Wabindato. I'm a program officer at the Indian Land Tenure Foundation. I have been with ILTF for just over 8 years now, and it has been a wonderful journey working with landowners, ag producers, and tribal leaders on various land issues. Today, I've been asked to talk with you about wills, estates, American Indian Probate Reform Act. And so there are a number of things that we'll go through. So let me go ahead and pull up the presentation. So again, my name is Jim Wabindato, and as we go through, I'll hope to answer some of your questions, perhaps raise some additional questions that you'll need answers to, but to talk about the transition of your trust assets to the next generation. It is critical for people to understand what this process includes, what are some of the exclusions or exceptions to the process, and how to better become active managers of your Indian land. It is one of the few tribal assets that we have, and so it's important to improve that understanding. And I'm hopeful that today's conversation will actually help bring you a little bit closer to taking a stronger role in that process. To start with, at our conversation last week, I threw around different terms, and there were different definitions that are always important. There are probably ways that I'll talk about these things, but there are, in the end, very specific definitions to what they are. For instance, I talk about restricted fee and say that it is like trust land, but it's not quite like trust land. Or the old-fashioned, if it looks like a duck, talks like a duck, it must be pretty much like a duck. In this case, though, we're hopeful. I'm planning to give you better definitions. Now, I did send an email to Dawn, and hopefully, as we get about a few more minutes into this, perhaps catch any last stragglers. But publication by the Department of Interior that will spend even more time going through what some of these terms mean. In a very sense, in Indian country, we think of 3 types of land, and that is probably the big 3. There are additional pieces that create nuanced interpretations of each of these, but for the most part, again, we're looking at trust land. This is land that the federal government holds title to or owns as a trustee to Indian people. The importance of that trust relationship is that as the legal title holder, as the actual owner, it gives them an outsized role in what we can do with that land. There are restrictions. Initially, it could have been said to protect the land and its Indian status, but as we have continued through history and time, it is becoming at times an impediment. There are still various occasions where that trust relationship can be beneficial, specifically if we get into an argument with the state that surrounds our tribal nations. But overall, within trust land, there are going to be tribal, public domain, and assignments. That's for Indian tribes. And then for individuals, those will be allotments that are trust land. Second class is restricted fee. We don't see that across a lot of Indian country, but it does exist. A restricted fee is similar to trust. Again, it has limitations on transferring it to other individuals through a will or through a sale, but the actual title in this case is to the tribe or to the individual. And finally, there's fee. In this case, within Indian country, land will be held by the tribe or it will be held by an individual under state jurisdiction. And most often we will end up paying taxes on that land. The key difference between trust and restricted versus fee land simple is the fee simple lands have no restrictions on them. So whether they're inside the reservation or off reservation, again, fee land has there are still zoning restrictions that might limit what you can do in using the land, but for the most part, it does not stop you from transferring it, leasing it, or doing anything at your own specific wish. And when I talk about land in real estate, there are a bundle of rights: possession, exclusion, enjoyment, control, and disposition. I've put in here that disposition and control are probably the two biggest things that trust relationship limits. Control means the ability to put together agreements for leasing, rights of way, to actually decide who can do what on the land. Disposition is that transfer that we talked about earlier. Enjoyment, exclusion, possession. Technically, all of these still have certain limitations because of that trust relationship. With restricted fee, it's not as likely to have some of the possession and exclusion, but you still do have issues with control and exchange. As I talk about trust land, it's important to understand that there is a piece of the American Indian Probate Reform Act. I won't cover this later, but it's specific to these rights of what is and is not trust asset. So in this case, if you're looking at land that might be in South Dakota, land that could be in Arizona, real property under a common law approach would suggest that anything or as here you can see surface, subsurface, airspace, and any improvements. And it's that any improvements piece. So when you build a house, it's considered part of the realty. When you build a fence, that's part of the realty. When you put a barn up to house your livestock or to take care of your farming equipment, that is part of the realty. In 2008, Congress was trying to avoid liability for contamination in buildings and other environmental issues. And so they passed a technical amendment to the American Indian Probate Reform Act, which basically severed all of those permanent improvements and in a very specific way, made them so that they are non-trust assets. When we are talking later about the importance of writing a will and how you want to deal with who gets your stuff, you're going to have to also add a different piece. And that's where, when we talk about wills, you'll need to make sure anyone who writes an Indian will for you is familiar with American Indian real estate principles. Not everyone is knowledgeable, and so that could potentially cause a problem for you. One last piece when it comes to what APRA has done in the form of land ownership and land control, I do want to share that it set out for approval of leases, rights of ways, a degree of participation that is required to approve any transaction. So in this case, we can see if it's you and your 3 brothers and sisters, pretty much everyone's going to have to agree because the APRA law will require at least 90% approval. And if it's that small, most likely it's going to be pretty much everyone. There may be a case where, you know, your auntie has 50% and then you and your 5 brothers and sisters split up the other 50% from your father. at which point, you could potentially have one person who disagrees, but you're still looking at pretty much everyone. It's when you start getting into the highly fractionated ownership that this scale made an improvement. It made it much easier. And it depends. When there are activities going on, it may give you the ability to make something happen, but most often and almost exclusively, or not exclusively, but almost all of the time, it will certainly allow you to veto a certain type of transaction if you can get the majority of interests. And when we're looking at these numbers and percentages, I do want to be very clear. We're not talking about the numbers. So if there are 20 owners, you're not looking at getting 11 owners to disagree. What you're looking at is the ownership percentage. And again, as I mentioned, maybe Auntie had 50% and then the other is split up. At that point, that Auntie can get you pretty close to either stopping a transaction or getting it across the finish line. You'll need to have enough to pass the threshold. So it's percentage ownership, it's not the number of actual interests. I see Don has added the trust land holding and types. Again, if this is something that you're looking for, it is a very good publication and it provides a lot of information to get into some of those nooks and crannies about what the differences are between trust, fee, and restricted fee lands. One last piece, and we'll kind of go back and forth about 3 different slides, is how that ownership is acquired. Tenancy in common is what most people have Indian land. It's only within the last 15 years that the American Indian Probate Reform Act has changed how probate is conducted at the federal level. And so you'll start to see more of what they call joint tenancy with right of survivorship, or as I refer to it, last Indian standing. So when we're looking at tenancy in common, we can see the original lottee had 160 acres. And after each successive generation, it got smaller and smaller. And so when you look at, say, the 3rd generation, each of those people will have in this case, equal voice at the table. And so when you're looking at this 1/9, it's not 1/9 of the acreage, or if we use a round number, 1/10. If you had a 1/10 ownership of 160 acres, it doesn't give you 16 acres that you can work with. It actually means that you have a 10% ownership voice or vote at the table. There is no 16 acres that your 10% will actually allow you access to. The only way you would be able to address something like that would be to do a different process that we're not going to talk about today, but the process is called partition, at which point you would actually legally cut your share of what you're asking for off from the master parcel and create a secondary parcel. So in this case, again, instead of having 1/3 or 33% of 160 acres, like I said, you have a voice at the table. This is tenancy in common. Each of these is treated separately from each other. So if I am 1/3, my brother is 1/3, and my sister is 1/3, I can give my 1/3 to anyone I choose, whether it be my wife or my children, and it has no direct impact on my brother and sister's land. And likewise, they can also transfer it to whomever they choose, whether it be by will, sale, or gift deed, and it has no bearing on how my ownership is put together. When I talk about joint tenancy with the right of survivorship, that is going to show up in our conversation with the American Indian Probate Reform Act. And what happens if we look at joint tenancy with right of survivorship in this 2nd generation? There are 3 owners, and equal shares. They each have 33.3%. With the last Indian standing principle of joint tenancy right of survivorship, when I pass away, now my brother and sister, instead of having 1/3, will each have 1/2. Mine cannot go to my heirs or to my children or to whomever I choose, because I have a remainder interest that I lose once I pass away. Now with 50% for my sister and 50% for my brother, when my brother passes away, our sister will have acquired 100% of our father's land, and she can then do with that as she chooses. So joint tenancy right of survivorship stops this process of fourth, fifth, sixth generation and takes each generation and pushes it backward to where it came from. So it's important to understand the difference between tenancy in common, which existed for most of the history of Indian trust land and restricted fee interests, with joint tenancy right of survivorship, which is a newer principle implemented by the American Indian Probate Reform Act. At this stage, I'd like to transition into the wills and estate piece of our conversation today, and just very clearly state that a will is a legal document, it's confidential, and ultimately a will is not final until you actually pass away. So you can change it as often as you choose. You can update it to include new assets. You can update it to include new people that you would like to inherit your various assets and stuff. But ultimately, although we say it is confidential, you're not required to provide this to anyone. It is still helpful to ease hard feelings, or to perhaps make it much easier once you have passed on, to talk about some of these issues with your family members. And I am a realist. I know that culturally, death is not one of those things that many of us are supposed to talk about. Also, there's just the issue of having these difficult conversations. As I've gotten older, I think it's gotten more difficult for me to think about the fact that I'm not going to be around forever. But ultimately, our land is surrounded by states. Our land is also surrounded by the federal government, and they have a very different system for land tenure than our community may have had historically. And as such, this Indian status land that is either trust or restricted fee, and including fee lands that may not be Indian status, they are subject to a different form. And in that legal system, it's critical to get a will to decide for you to choose who is going to get your stuff. The American Indian Probate Reform Act was passed in June of 2004, but excuse me, let me rephrase that. The American Indian Probate Reform Act was passed in 2004, but it took effect for all probates and all those who died after June 20th, 2006. So if someone had passed away in 2005, but the probate didn't show up until 2006, their estate would still go through what would most likely be the state's role in how people are probated. But as we get closer and closer, that becomes less of an issue. Where it can have an impact is, again, when something is changed in a previous probate, it may end up having a cascade effect, so that for 3 or 4 generations, they'll have to go back and redo a probate. It is a painful process for the feds, and it's a hard process for us Indian people, that something we may have thought was ours gets changed because the Department of Interior made a mistake at an earlier stage of this. 2 important pieces that you see here are that the American Indian Probate Reform Act strongly encourages you to make a will, and mostly it causes you to write a will, because if you don't, the law, as well as a probate judge who works for the federal government, will then decide what happens to your stuff. So if you don't write a will, you're putting yourself at jeopardy and at the whims of a judge. And that's a difficult pill to swallow as well. Land is very important. I've used different terms and I've tried to be careful, but ultimately I want to make sure that you guys have a chance to see these things in writing. An heir is a person who receives property under APRA, and specifically if you die without a will. An eligible heir without a will has a very limited option. So in this case, we're talking about Indian people and co-owners. We're also talking about your immediate family members. And it does in APRA provide that non-enrolled Indians or non-Indians, depending on kind of your perspective, but your grandchildren might not meet the blood quantum requirement and cannot enroll at the tribe. It is possible within that 2 generations for them to be able to inherit your Indian land. And finally, eligible heir with a will, and legally that's known as a devisee. And so if I go back and forth, I'll try to be specific about whether you have a will or not. But ultimately, again, APRA really, most of its impact is felt when you don't write a will. And so a lot of our conversation will cover that. But with a will, in theory, anyone who's a lineal descendant of you can inherit your land without whether or not they're enrolled at a tribe. So again, if you're looking at multiple generational jumps for your land, with a will, you can give it to a great granddaughter who, because again of Indian blood quantum, may not be able to be enrolled. They can inherit your land with a will, and it will still maintain its Indian status. Now, what happens 4 and 5 generations down the road? That's not to be, we haven't seen what that means, but it's important to realize that there are different definitions depending on whether or not you have a will, and that ultimately an heir is somebody who can take it and keep its Indian status. Again, I start with very basic terms because they have a role in these more complex issues. But trust assets are the fee, trust or restricted fee land and individual Indian money account funds. So IIM account funds are part of your trust assets, as well as the Indian land that you have. So those are the pieces that are going to be probated by the federal government according to either APRA or another statute. Not trust includes permanent structures on trust land, and that's critical. The Indian Land Tenure Foundation is trying to change that, but as of today, and for the last almost 15 years, again, it's important to put forward a process that that house that's built on your land stays with the land, or that it's very clear on why you're giving it perhaps to one of your other children versus the child who may have the land. I would hope that a lot of our kids can get along, but that's not always the case, unfortunately. Any other personal property, grazing permits, and tribal land assignments, those are not trust assets. Those are things that you can use, and those agreements are with you. So when you pass away, those agreements are legally things that you may have had possession of, but you surrender, well, not surrender it, but you lose that when you die. And so your kids may have to work with the tribe on a land assignment to get it. Each tribe addresses land assignments differently. They may have leases instead of land assignments. And so that house that you built as part of a HUD program may have its own set of rules. And so when you're dealing with that in your will, you're going to have to understand that it's not going to go through the Department of Interior. And so there's going to be a different process depending on how your tribal leaders have put that process in place. I've kind of alluded to this earlier. So there are three assets: trust, lands, and funds. Those are probated in federal court. Non-trust assets are probated in state court. And you may have a tribe that will do non-trust assets. I believe the Navajo Nation is one of those, with a comprehensive probate code, which will address non-trust assets. They would not go under either Arizona nor New Mexico. They would actually go through the Navajo Nation court system. Tribal and cultural assets are usually done by tribal custom. They may be also something that would go through the tribal court. So again, it depends, but the most important piece of today's conversation is those trust lands and trust funds, because depending on what rules are in place, again, it may limit what you can do with those. So what happens when you pass on under APRA? There are going to be, if you pass without a will, it determines who receives your trust property and trust money. A valid will allows you to choose who gets your trust property and trust money, but it may still limit who can actually get that. So again, as you're thinking about this, it's important to come back to the APRA law and look at the APRA rules. It does not, there are 20 tribal communities that do not follow the American Indian Probate Reform Act, and I'll show you what some of those are. And primarily it begins in the 70s, but there are a couple of laws that preceded that. So the Klamath tribe in 1938 had a probate act of Congress put in place. I refer to as 5 tribes. That's the Cherokee, Chickasaw, Choctaw, Creek, and Seminole. But within that broad umbrella, you can look at the tribal towns, which are culturally and historically tied to the Muskogee Creek, as well as the United Kituwa Band of Cherokee. These are communities that may have land in Oklahoma, and it would be probated under the Stigler Act. The Stigler Act provides for state court system to actually adjudicate and make a decision on those probates. As you can see here at the bottom of the list, in the 70s, a lot of the Columbia River Valley tribal communities had probate acts. Again, I say act because it's an act of Congress, and these predate the American Indian Probate Reform Act. Finally, we look at Osage, and then we get into the Dakotas in the 80s. Standing Rock, Spirit Lake, and the Sisseton Wahpeton Oyate are 3 Lakota communities that do not follow the American Indian Probate Reform Act. So with APRA, it did provide that tribes may choose to create a new or update a probate code that is compliant with the intent of the Indian Land Consolidation Act, and which the APRA law is part of. And here we see the Confederated Tribes of the Umatilla Reservation updated their law shortly thereafter. Northern Cheyenne, as well as the Fond du Lac Band of Chippewa. What we begin to see with Lake Traverse, Umatilla, and Fond du Lac as this idea that they want tribal members, tribal citizens to have ownership of the land. And even as an Indian person, it does exclude others. So with the Fond du Lac Band, they're part of the Lake Superior Chippewa, part of the Ojibwe Nation. Under their probate law or act code of 2015, they made it so that if you happen to be one of their cousins of the Lake Superior Chippewa, whether it be, say, Grand Portage or Red Cliff, you're no longer eligible to inherit Fond du Lac land. And that has a very clear meaning. During the land buyback program, if I happen to be a Red Cliff citizen, I could look at the fact that through my grandmother, I got Fond du Lac land, and then have made a choice that I was either going to sell it to a cousin who is Fond du Lac, or I could have more directly sold it through the land buyback program. And so you can start to see that these federal policies are crystallized on getting land consolidated under the tribe. And it's not necessarily set up to work best for Indian people, but if we know what the rules of the road look like, we can certainly work with that. So again, I'll go backward real quick. Klamath, 5 tribes in Oklahoma: Yakima, Warm Springs, Nez Perce, Umatilla, Osage, Standing Rock, Spirit Lake, Lake Traverse or Wahpeton, Northern Cheyenne, and Fond du Lac do not follow the American Indian Probate Reform Act. So if anything, when you leave today, should you know that you have land on one of these reservations, it's going to be critical to do extra legwork. I don't have information that I can share succinctly today on each of these, but to know that it exists is important as you're doing some of your estate planning efforts. Under APRA, there are really two sets of rules or two pathways that are followed by the judges. There are a set of rules that apply when the ownership is 5% or greater, and there is another set of rules that apply when it's less than 5%. And at this stage, I'm going to talk primarily about what happens if you do not write a will. If you die what they call intestate, you did not write a will, and your land is going to be subject to the understanding of the American Indian Probate Reform Act by an Office of a Hearing and Appeals Judge under the Department of Interior. So again, without a will, you're surrendering any opportunity you have to make sure you get the land or trust assets to those that you want. I may find that I haven't spoken to my daughter in 20 years and I want to bypass her and give it to my grandkids. Under APRA, I can't do that unless I write a will. So without a will, who is eligible? This is a long list, but it pretty much says that if you're an Indian person, under a generally understood definition of that, as well as lineal descendants, meaning your kids is the first generation, your grandkids are going to be the second generation. Without a will, under APRA, again, they can inherit your land by the judge, assigning it to them, and it will still maintain its Indian status. And again, this set of eligible heirs without a will is regardless of the size of the ownership of the land. So whether it's 5% or 0.00002%, the same eligibility stands. So if you die without a will and your interest is 5% or greater, it's going to pass to your eligible children in equal shares. So again, when we've got, say I have a 10% ownership with 2 children, each of my children is going to get 5%. Now going back to what I talked about, now this is under the American Indian Probate Reform Act. So if I should die next week or next year, my 10% goes to my 2 daughters in 5% shares, but as you recall, I didn't write a will, and so the APRA law requires the judge to assign that to my daughters as joint tenants with the right of survivorship. So because I didn't write a will, one of my 2 daughters is going to end up shortchanged, which means one of their kids may well end up shortchanged as well, because under the law, it's very important to understand this. Under the law, without a will, you're going to be required, the judge is going to be required to transfer it as joint tenants with right of survivorship. So, and I think about this, it's just ultimately means that, you know, some of your grandkids and great grandkids aren't going to get access to your Indian land. So again, it really forces you to think about writing a will. Now, I do want to, before I move on, pass along a quick story about some landowners in Nevada. This woman, she wrote a will, this elderly woman, wrote her will, worked with an attorney to write the will, but unfortunately the attorney didn't adequately understand what APRA says. This woman wrote a will and assigned equal shares to her children, and everyone, including myself, would have believed that she meant for them to get it as tenants in common. The attorney wrote that it would go to her children in equal shares, and that was the end of the sentence. She did not address the issue of tenants in common or joint tenancy right of survivorship. And because that will was successful, but it did not provide direction, the judge again was required to assign it to the kids as joint tenants with right of survivorship. And the scarier part of that is nobody understood what that meant until about a year later. The gentleman who was at my presentation heard me talk about joint tenants right of survivorship, heard me talk about APRA, and said he was really frustrated with the Bureau of Indian Affairs. He found out when he went to write his own will for his kids to get his land, that he didn't have the legal right for them to get it. And as soon as he said the words that his kids couldn't get his land, I knew what had happened, because we talk about this at the Indian Land Tenure Foundation a lot, which is even with a will, sometimes there are things that happen if you don't have somebody who's familiar enough with Indian land issues. It's not enough to go and find an attorney who's going to write you a will, because you have these trust assets, because you might have your business operating on your trust assets, to know what those rules are. And if you don't, find somebody who will. We do provide at ILTF for certain landowners, and eventually we'd like to have it for more landowners to write a free will for themselves. But to do it pro se, to do it by yourself, may miss some things. And so we always will provide opportunities and tools, but we still recommend that you work with someone who knows Indian law. This is a continuation of all those things. When they wrote APRA, it basically is like a handbook. It goes all the way down to what happens if there's no tribe with jurisdiction over the land and what's going to happen to it. And ultimately, again, because there is no will, the federal government's going to figure out what they want to do with it, regardless of your wishes. This is your trust interests. It's probably going to be kind of hard to see. I did provide a copy of the presentation to Dawn, and so you may be able to request it. But again, you can kind of see if you have a surviving spouse and children, your spouse may get a life estate, which means they can use the land as long as they're alive, but your kids are going to have the remaining interest, your remainder interest. And so when your spouse dies, that will go to your children. And again, because you did not write a will, it's going to go to them as joint tenants with right of survivorship. And it may seem odd to say surviving spouse, but for those of us who may be in second relationships or third or fourth relationships, you can start to see that the surviving spouse may not be their parent. And so these rules provide that the land stays as Indian status land. And ultimately, if you don't have anybody, it's going to go to the tribe. I have seen that. In fact, when I was in Arizona at the Tohono O'odham community, the San Javier Reservation, we were trying to figure out, without a will, is it still possible for the deceased's intended nephew to actually get access to the land? And again, because there was no will, that nephew is not a lineal descendant, and there was nothing that allowed for that nephew to get it. Had their sibling been alive, the nephew's parent, the parent could have gotten it under APRA as a part of that immediate family tree. But again, without a will, unfortunately, it went to the tribe and it left individuals. Without a will and interest less than 5%, I'd thrown out the term Indian Land Consolidation Act. The original Indian Land Consolidation Act was passed in 1983. There were a couple of amendments to that law because it initially just took the land and gave it to the tribe if it was less than 5%, and that was unconstitutional taking. And there are some court cases that I could share with you later, but in the end, in 2004, they did a comprehensive probate process, and it has stood up to the test of times. And ultimately, APRA is legally a component of the Indian Land Consolidation Act. And the reason I say Consolidation Act, Indian Land Consolidation several times, is that is the motivation of the federal government. Again, the rules they make are to resolve their problems. They're not designed to make life easy for us. They're not designed to make it work for us. It's designed to make it work for them. And so the component of APRA is this single heir rule. So if you have a less than 5%, you could even have 4.5%. But if you're at 1% and you do not write a will, you're going to see that go under the single heir rule to your oldest eligible heir, or in this case, oldest eligible living child, for instance. Again, when I tour and talk about APRA, when I talk about land ownership and land management in tribal communities, it's not uncommon for me to hear somebody ask why their older brother had land that they didn't get. And I can immediately point them to this rule that they were the youngest, or they were younger than somebody else in their family, and that their mom or dad did not write a will. Again, having talked about this for a dozen years, or for quite a while, these are some of those questions I can answer without even knowing too many details. Without a valid will, here's what you can see with the trust interest. It looks a lot like the other one, except the single heir rule starts to apply very quickly. Your IAM account follows a slightly different process. Because they're not concerned about consolidation of money, they're going to try and pay it out. They're going to try and eliminate that IAM account as quickly as possible. It's expensive to operate the trust accounting system. That is one of the other strong purposes for having something like APRA in place. The Indian Land Consolidation Act in the first place is for every trust account that exists, it costs the federal government money. It's not uncommon to still think of us as Indian people as that Indian problem because it costs. And so with an IIM account, they're going to try and get that money out and get those accounts closed and relieve themselves of that burden. Here is something I kind of cover. You should change your will if you've been recently married or divorced, if someone you named has passed away or has become mentally unable to handle their affairs, you recently had or adopted a child, or you recently purchased or sold property. So anything that changes what assets you have means that you should go back in and change your will. If anything changes in your life circumstances, you need to take a closer look and probably go in and make changes to your will. One of the other stories that happened here in northern Minnesota had to do with the fact that a lot of us Indian folks will get legally married, but we don't also always get legally divorced. And so I want to share with you that it's important, if you separate from someone, that at some point you do actually need to complete the process and get a legal divorce. In this case, a younger woman came in and her father passed away right in about mid to late June of 2006. And that is that critical date that APRA starts to apply. He had passed on shortly after his mother had passed on. And so there wasn't a lot of time perhaps for him to think about it. But when he died, he was still legally married to someone who was not their mother. And those two had not been together. He was in northern Minnesota. She was south of the Mason-Dixon line in another state. Well, when she found out that he died, she knew she was still legally married to him and showed back up in the tribal community. At that point, she was able to access some of the tribe's burial funds, which should have gone to the family to help with burial expenses. But as a legal spouse, she still had rights. And so it's important to realize that not only under a will, but under your estate planning, if you're not with an individual, make sure that that has legal separation, because under the law, they will have rights. Fortunately, even as a spouse, legally speaking, the American Indian Probate Reform Act took away any rights she may have had to access the land, because the spouse can get at most a life estate without a will. But these are all things that when you're looking at your circumstances could stop your stuff, your land, your trust assets from going to the people that you want to have them. And you've worked your life to have those. You've, have an important role with your family in shepherding those through time, through your ownership, and ultimately to your kids and to your future progeny. So again, you should change your will, and you should make sure your legal status is very clear when you're talking about estate planning issues. Getting towards the end, and then I'll get a chance to look at some of your questions. I know that Don will then kind of jump in and we'll go back and forth a little bit over those. Consolidation is possible without having to choose family members over another, because it can be tough. If I've got something, do I give it to, to this daughter, or do I give it to that daughter? Do I split it equally? ILTF will most often suggest that you take a look at how you can consolidate. If you've got a number of interests around the reservation, maybe give your whole ownership of those interests, those fractional ownership pieces, to one child, and give different interests to another child. You can give a life estate to your spouse. Let me see here. Number 2 is what I was talking about already. If for some reason you just don't want to make a choice, you can use joint tenants with right of survivorship. Again, somebody's going to end up on the short end, but to be a little crass about it, I'm going to be dead. So it really may not mean as much to me, because I won't see what that does. But hopefully we're a little bit more deliberate, and joint tenancy with right of survivorship is not as evil as I make it out to be. It is a tool. It is something that is legally available. Ultimately, you may try and improve their financial situation. You could request a sale at probate, and one of the other co-owners, perhaps the tribe, may step forward to do a purchase in the probate process, at which point your family members would get cash instead of the land. So those are all different ways that you can look at consolidation that address. One last tool I want to say that is in your arsenal as a landowner is a gift deed. It transfers your legal interest. We put in here, gift deeds are not revocable. What that means is once you've gotten the gift deed recorded and I've transferred it to my daughter or to a granddaughter, I can't change that. I can reserve a life estate. I can continue to use it as long as I'm alive. But legally, I have made that individual the new owner of the land. And as we have seen in earlier days, perhaps alcohol, in more recent days, different drugs, sometimes we lose our family members to those situations. And under a gift deed, it is possible that you could have transferred it to them and the family loses it. Now, if you reserved your life estate, you still get to keep using it, but you'll know before you pass on that drugs may have caused that land to leave your family. So a gift deed is a very good tool, but I mentioned the worst case scenario because it is something to think about before following that pathway. Because I think for a lot of us, we can perhaps skip a generation, gift deed it to one of our grandkids or to maybe a couple of grandkids, and know that they've listened to our stories. They understand the role that that land has played in our family's history, and that they will share that with their kids as well. So a gift deed is one last tool that you can look at. It's not explicitly estate planning, but it is part of the estate planning process, and it is something that is available to you as an Indian landowner. That is the end of my presentation, so let me go ahead and switch back to the visual.
Thanks, Jim. That was really good. We do have a few questions in the chat. If you'd like me to read them, I can, or you can just check them out, whichever you prefer.
Sure. Let's see. Land on trust land belongs to husband. Okay, so it asks, a home is located on trust land that belongs to the husband. If the husband dies but does not write a will, does the home go to the spouse or to his only child? In this case, let me preface this by saying I'm not an attorney. I'm not providing legal advice. I'm suggesting on my interpretation of how this works. So in the end, that I would strongly recommend getting a will written, and then you can explicitly deal with that situation. But as I understand it, even if this person is an Indian person, even if this Indian person is a tribal member of the tribe, because the land would be titled to the individual. Now, again, a lease is different. Lease comes from another party, so it might fall under tribal rules and regulations. But the federal process would suggest that this wife may well get the house, but not the land underneath the house, because the house itself is not a trust asset. ILTF is trying to change that. That's a travesty, and it creates a headache and trying to figure out who gets what and how. As part of this, we do try to see what we can do to change things. We thought we might be able to put together a friendly case, some brothers who get along and weren't going to be fighting each other, and try and force the federal government to deal with this by having them fight over the house. Unfortunately, Dad got a hold of a good attorney and it was done appropriately. So we didn't really have that chance to try and force the federal government to deal with this issue. But we are looking at legislation that can more cleanly get it. I talked about restricted fee in the way of land ownership. Restricted status for the house may help to address some of that. But again, that would only ensure that it goes through the same federal process that the land does. It doesn't specifically address the question that's on here. And so again, my understanding is that if he dies without a will, the home may well go to the wife, but again, the land is going to be handled separately regardless. Let me pull up the question. So non-native spouse can take trust land even though he or she is non-native. How does this happen? I didn't quite say that the non-native spouse could take the trust land. So let me kind of back that up a little bit. Under the American Indian Probate Reform Act, which covers most tribal communities that have allotments, a non-native spouse would at most get a life estate. The life estate may allow them to enjoy lease revenues. It may allow them to continue living on the land and in the house that's on that land. But even as a native spouse, without a will, that individual is not going to get it. There is legally another way. If a native spouse writes a will that gives their Indian land to a non-native spouse, it will probably get tossed out. That's a tough question that an attorney really should address, because under most standards, they should have the right to give it to the non-Indian spouse, but you know, the Indian children or the tribe itself will probably fight it regardless, and therefore may end up buying that from the non-native spouse. Before, when I worked for a northern Wisconsin tribe, we were seeing that this occurred prior to APRA. All of the interests went to the non-native spouse under Wisconsin's marital property laws, and the interests went out of trust. APRA was designed to stop that process and change it so that those interests would not continue out of trust. I mean, if you think about what a pain in the butt it is to manage all of these interests under trust status, there are a lot of non-trust interests that, you know, tend to get glossed over very quickly. You see, next one, California, children didn't follow up. Can it be transferred or bought? So In this case, I will highlight under the probate process, it is the family's responsibility. The Bureau of Indian Affairs probate office does go through obituaries, but they're not required to catch everything. And so it is the family's responsibility to get a copy of the death certificate. And with that death certificate, they can initiate the probate process. In this case, you may find yourself in a slight conflict. Even though the children may not have followed up in this case, they still have these eligible heir rights. So I could begin a probate process on my brother, but his kids will still have rights that supersede mine. There is the ability as a co-owner to request a purchase at probate. That's a whole nother thing. And if anyone is interested in these purchase at probates, you can get a hold of me later and we can dive deeper into it. But generally speaking, the family provides the death certificate to the Bureau of Indian Affairs, and that will initiate the probate process, whether it be 5 years ago, 10 years ago. Let's see, family 7, most recommended way to will trust land is joint tenancy in common. Many others are listed in the trust already. Sure, it stays in the family for future generations. That's an age-old question. I cannot say that there is a best way to deal with that. Unfortunately, it's a personal decision. If I'm looking at this, in fact, actually, I can tell you, ILTF has been active in helping Indian landowners get wills drafted pretty much since I've been at ILTF. And even as early as 2004 when APRA passed. So in 2006, 2007, we had actively pushed foundation and federal funds into will writing. And although ILTF may push for people to consider consolidating principles, like I said, interest over here to one kid, or interest over here to another kid, it's none of my damn business if they decide to do it as joint or as tenants in common. Yes, it will continue the fractionation of ownership, but again, that's the federal government's problem, and there is no best course of action that I can say uniformly that family members need to follow. So ultimately, if you don't want to lose the land, I would say that conversations about what having Indian land is about. I've got a family in Oklahoma that I'm going to see in mid-May. We're working on a project about corporate ownership and taking a different perspective on Indian land ownership. In their case, they, well before ILTF showed up, were convening family meetings, and they would talk about what's going on with their Indian land. They would figure out how do they work together for the common family good. So much so that I say their kids are maybe about Dawn's age, but these kids have known this stuff since they were, coloring in coloring books. So now that their grandkids or their kids are coming in, that third generation, the current, the current landowners are in their mid to late 60s and early 70s. And their grandkids now come to the meetings. When I meet with them, I expect that we'll have conversations with the grandkids about, what does this stuff mean? The current owner generation has a pretty good sense. Their kids understand the critical issues. And that's, I think, without saying a lot more about it, is the best way to ensure that it stays in the family for the future generation. Is you need to talk about it openly. You need to talk about what a pain in the ass it can be to deal with the Bureau of Indian Affairs. You need to highlight what is the tribe doing over land ownership and land use within the reservation community. Education and outreach is critical. That's why I was talking with one of my colleagues. I think I've done a version of this presentation 35, 40 times over the last 8 years. And I've probably talked about it more than I can even remember. But ultimately, knowing about land ownership, knowing about what these rules look like, knowing the law. In fact, in most of my conversations, I'll talk about knowing the difference between what a regulation is and a statute. You know, a lot of times when we talk about leasing, we'll highlight, well, what is CFR? What is CFR? And CFR is short for Code of Federal Regulations. It is the roadmap that the Bureau of Indian Affairs must follow, but ultimately it's an interpretation. Go back to the statute, see if you agree with the statute. There may be options and opportunities under the law that Congress passed that you disagree with the Bureau of Indian Affairs, and that's your right. It gives you perhaps space to push what you want to do to ensure that that land that your family has had can continue to do the things you want. Let's see, adopted children who are not Indian. Let's see. I want to say that, let me see here. Still have my presentation up on eligible heirs. So I apologize for not looking at the screen. Let's see here. Let's see, lineal descendants, meet the definition, California co-owner, eligible to become a member. So eligible to become a member or a lineal descendant within 2 degrees is what they use for not having a will. If this Indian mother should write a will, I do believe I recall seeing adopted kids who may not be Indian are still considered their kids. Again, because it's very specific, I would recommend talking to an attorney to make sure that it meets your expectations and is compliant with the law. But overall, I do believe adoption makes these kids yours, and therefore would make them part of your immediate family and therefore eligible Indian or not as 1st or 2nd generation. Again, that's my interpretation. Please talk to an attorney and you can get the correct answer for you.
All right, Jim, we're coming up past 12 o'clock. That was really good. All the questions were wonderful. So thanks everyone for being with us today. If you have follow-up questions, I will place emails and websites in the chat right now. That way you have them if you don't already. So that's ITLF's info. Here's our Occupton info. There's nothing else on your end, Jim. I want to really quick mention our producer survey. We're asking all of our clients to participate in our market study. You have a chance to win some incentives and also be a part of making things a little bit better as far as it goes for programming and funding and things like that. So I'm going to put that in the chat as well. If anybody has a moment, please fill it out. Let me know if you have any questions. We also have a summer internship program here at Occupton, and we will be closing that on Friday. So please let folks know. Thank you again, Jim, and everybody for attending. Let us know if you have any questions.
Thank you, Dawn. Thank you, Occupon.
All right. Have a good day, everyone. Thanks. Bye-bye.